I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my abandoning co-host, Brett.
I would never abandon you, Alice, nor would I abandon an obviously viable legal strategy to allow someone who is very clearly a murderer to have a new trial. But that's just me, and I'm not the Attorney General of Oklahoma because I don't own half the state. So I'm just here having to tell it like it is.
Well, if you're not abandoning, then let's talk about someone who is and who ended up at the Supreme Court today. And everyone's favorite topic, Supreme Court oral arguments.
Yay. They have started again.
Actually, that's not a joke. Oh, yeah. Welcome to the new term. So for those of you who,
the newest season.
The newest season of the Supreme Court SCOTUS. Just kidding. So for those of you who followed us long enough, sometimes if you have an interest in us covering either a Supreme Court argument or a Supreme Court decisions mostly come out throughout the year, but they all have to be out, by the end of the term, which is in the summer. But the new term starts in October of each year. And Monday, October 7th, was the start of the new season of this Supreme Court. And it started off with a bang, as it always does, and it will continue to be banging all year. The whole oral argument calendar is not yet filled. So if you want to be on that calendar, I don't know, get you a Supreme Court lawyer and file some cert petitions. You just might be on this newest season of SCOTUS.
Yes, exactly. But I'll tell you what, ordinarily, there are a couple ways you end up in front of the Supreme Court. Either you have a really good argument, there's like a really good, interesting question, important question, or something really weird happens in your case. And this is definitely one where something extraordinarily strange has occurred in this case, which is a famous case. We're talking about the Glossip case today, which is back in front of the Supreme Court. If you've followed this for a long time, you know this is not the first time that Glossip's case has gone to the Supreme Court. He has filed many, many appeals of his conviction in Oklahoma for murder and subsequent death penalty, all of which have failed. But recently, he has been given new life, I guess, by the new Attorney General in Oklahoma, who, for reasons as we're going to go through, decided to actually support his motion to vacate his conviction. Still thinks he's guilty, wants to retry him, but did support his motion to vacate on the basis of a couple different claims that are actually the same claim, though they come from different Supreme Court cases. He has a Brady claim, and I think this is the first time we're going to discuss the... Alice, can you pronounce this for me?
NAPU. It is
case.
Exactly like you would not think it's pronounced.
Yes, NAPU. So we're going to get into it. We're going to tell you exactly what happened. But before we do that, we want to start off with sort of a statement of this case. For those of you who don't follow it, it's a case that's relatively famous in true crime. There are a lot of people, for reasons that are entirely unclear to me, who think that Glossip is innocent. Sometimes you'll see this presented as Oklahoma is trying to execute a man who didn't murder anyone. That's because he paid someone else to do it, to beat someone to death with a baseball bat, as a matter of fact. So let's go through the facts of the case. So I'm just going to read to you actually from the brief in this case. One thing that's really interesting about this, ordinarily, the way this would go, when Glossip would file this is his 7th or his 8th petition to vacate his conviction, the state of Oklahoma would oppose it. It would go up through the Oklahoma system. Then it would go to the Supreme Court if it made it that far. Oklahoma would represent the interest of the prosecution, defending the conviction. And Glossip and his lawyers would argue that his conviction should be vacated. In this case, though, because the Attorney General, as we said, is on Glossip's side, the Supreme Court actually had to appoint someone to represent the prosecution in the position that the conviction should be upheld. In some ways, this is kind of like the Adnan Syed case, except that because of some things that happened in Oklahoma, there's at least one really important group of people in Oklahoma who think that this conviction should stand, and that would be the courts, because in Oklahoma, unlike in the Adnan case, you remember one of the problems we had with that was Adnan and the prosecution, they got together, they decided they were going to vacate the conviction, and the judge just went along with it, didn't test the evidence, didn't hold them to their arguments, didn't ask them any questions. It was a complete fait accompli. That was not what happened here. Here, the Oklahoma Court of Appeals, who is the final arbiter of these criminal cases, said in a 5-0 decision, no, we're rejecting the position of the Attorney General and upholding this conviction. And so at that point, it goes up to the Supreme Court, and now we're in a situation where we have 3 parties arguing: Glossip, the Attorney General, and the amicus who was appointed to represent the position that his conviction should remain.
And just as a side note, not all oral arguments are created equal. Obviously, this is a famous case. It's gone up to the Supreme Court multiple times. It's a case that's well known. It's a procedurally unique case because the Attorney General has abandoned, kind of their previous position of fighting for the conviction. But also, all oral arguers, oralists? Oralists?
I don't know. Oralists, I think that's what they call it.
Are not created equal. You can listen to all of the oral arguments on supremecourt.gov. They post them live, just audio, no video. And the same day, you could probably also find it on YouTube. So you can listen to every oral argument. But there were kind of 3 big hitters who were all arguing in this case. 2 of them have been previous U.S. Solicitor Generals, Seth Waxman, arguing for Glossip, and Paul Clement, who was also a former Solicitor General for the United States, arguing for Attorney General Drummond. And then the amicus appointed by the court was a previous assistant SG. I forget if it's associate or assistant. Not the SG, but someone who worked in the SG's office, Chris Michel, who is younger than the other 2, I think, but definitely an up-and-coming Supreme Court lawyer. And all 3 were really excellent. And it's fun when you get good oralists in front of the court. This is kind of a side note, because it really becomes a discussion among the lawyers and the 9 justices, which is a really hard thing to do. If you've ever had a conversation where it's like 9 against 1, it's not always a fun conversation. And sometimes when you have a lawyer who's not really up to the task, you'll see all of the justices melt away with their questions because they're like, we're not going to beat a dead horse. Like, he's not going to be able to answer the question. But if you're volleying it back and forth with the justices, it gets to be a really fun activity. So just throwing that out there in terms of if you want to hear a fun argument, these are good oralists to listen to.
And I mean, for this issue being what it is, I have no idea why these people were arguing this case. I mean, I guess I understand.
This is not like the meatiest of legal issues. It seems pretty clear cut, to be totally honest.
Paul Clement may be the greatest living Supreme Court oralist. We'll go with oralist.
He may be one of the top 2 or 3 most frequent visitors to the Supreme Court as an oralist.
Yeah. You want to know who killed
in
Chevron?
History.
It was Paul Clement. He argues, if it's a big case, he argues it. I have no idea why he was in this case. And the other thing, I mean, I don't know if he did this for free, but I mean, the man is highly sought after. I assume he has pretty high billable hours. Oklahoma, I'm talking to you out there, Oklahoma, and you taxpayers out there in Oklahoma. Look, if the state of Oklahoma paid Paul Clement to do this, y'all need to be asking some questions, because y'all got some great lawyers in the Oklahoma AG's office, including a solicitor general whose job it is to argue in front of the Supreme Court. And I have no idea why you were paying Paul Clement. If you were paying him, maybe he took this one just out of the goodness of his heart because he's friends.
But also don't understand if he took it for free, because he doesn't need to take things for free.
I don't either. It's bizarre that he was arguing this case. So I have no idea what's going on there, but maybe find out whether you guys just paid $150,000 for that.
Behind the robe gossip about Supreme Court practice. Let's actually talk about the case, because those of you who don't know the facts of the case, I do think this is important. Oftentimes you'll get legal issues up to the Supreme Court where you're just talking about procedural bars or jurisdiction, and you don't get into the meat of the facts of the case. We actually get into the facts of the case because the facts are specifically what are at issue here when you're talking about a potential NAPU or Brady violation. So for those of you who don't know the facts of this case, we'll go through it for you.
And I'll just say we didn't get in the facts enough, I thought, because there was a lot of talk about procedural bars. We're going to get into that in a second, but we'll give you the facts for those of you who are not familiar with this case. And we're going to be reading from the brief that lays this out. This case has been well litigated. You can Read all you want to about it, and this is sort of the basic rundown. So Barry Von Treese owned the Best Budget Inn in Oklahoma City. Petitioner, that's Glossip, was its manager. Van Treese could not visit the property much in late 1996 as a result of family tragedies, and the motel fell into physical and financial disarray during his absence. Van Treese blamed Glossip for the mismanagement and suspected that he was also stealing money. On January 6, 1997, Van Treese inspected the motel and told Petitioner that he had to produce certain missing receipts or he would be fired. Van Treese then traveled to a motel that he owned in Tulsa and returned to the Best Budget around 2 o'clock the next morning. Shortly after that, Glossip knocked on the door of Justin Sneed, a 18-year-old high school dropout who was, quote, totally dependent on Glossip for work, a room, and food. Sneed had little, quote, mental presence and, quote, didn't make a lot of decisions. This is all from the trial. And from Sneed, frankly, his own descriptions of himself. He often had to be told what to do and how to do it, and usually the person who was telling him what to do was Glossip.
So you may be able to see what we have going on here. Pretty mentally vulnerable person, young guy, who is suddenly hearing a knock on the front door by our man Glossip. But what about? So in Sneed's motel room around 3 o'clock, Glossip told him that he would pay Sneed $10,000 to kill Van Treese. Otherwise, Glossip said they'd both lose their jobs. So Sneed better do this. It was good for both of them. And Sneed agreed. He went to Van Treese's room, entered with a key that Glossip had given him, because remember, Glossip is the manager of this motel, and Sneed beat Van Treese to death with a baseball bat. Terrible way to go. Sneed told Glossip that he had killed Van Treese, and Glossip went to Van Treese's room just to confirm that Sneed had in fact done the deed and that Van Treese was dead. Glossip then instructed Sneed to drive Van Treese's car to a nearby parking lot and said his payment would be in an envelope under the seat. And Glossip knew that there'd be money under Van Treese's car seat because he knew that's where Van Treese kept all the cash proceeds from the motels. Now, Sneed did as he was told, not only in killing Van Treese, but also in driving Van Treese's car and looking under the seat, and he found $4,000 in cash, which he split with Glossip. Glossip then told Sneed to buy some acid, a hacksaw, and trash bags so that they could dispose of Van Treese's remains. But this is a motel. There are people who work there. So people who work there start coming in the morning, and early the next morning, Glossip tells a motel worker that Van Treese, he'd left to get supplies for remodeling the rooms. Don't worry about it. I know he was here yesterday, but he just ran out to do some errands. And the housekeeper also shows up, and he told the housekeeper, don't worry about the downstairs, just clean the upstairs rooms, and that he and Sneed would take care of the downstairs. And he says this because Van Treese's dead body was, of course, downstairs.
So, unfortunately for them, the fact that Van Treese was missing didn't remain secret as long as maybe they had hoped. Van Treese's car was found, and the police started looking for him. So, when Glossip returned from shopping for an engagement ring with his girlfriend, he gave the police 3 different accounts of his last interaction with Van Treese, while indicating that he had searched the motel looking for him. And as we know, whenever you start telling the police different stories, particularly that quickly, like it's not like they talked to him, then he told a different story like 2 weeks later, then he told a different story 2 weeks later when, memory changes, everything else. I mean, he really can't even keep a story straight in these initial conversations with the police. So the police are now suspicious of this story, and an officer, sort of while they're talking to him, goes and searches the hotel on his own. And what does he find? He finds Van Treese's body. At this point, Glossip is arrested, and he's found with $1,757 on him that largely he can't explain why he has that much cash. So he initially denies any involvement, and then he's like, okay, you got me. And he admits that he helped Sneed clean up the murder scene and cover up the murder, but that he was not involved in the murder and he didn't know anything about it. And the police then go after Sneed. They find him about a week later, and much like Glossip, he also has some unexplained cash, around $1,200 on him. He admits his role in the murder, and he tells the police the story that we just told you about Glossip's role. At this point, Glossip's conviction has been affirmed 6 or 7 times. He's actually been tried twice. His first conviction was overturned because his defense attorney was incompetent, was found to be ineffective, which is very rare, but apparently was. So they overturned his conviction. They tried him again. He was convicted again. And since then, he has been on Oklahoma's death row. He's been pretty close to being executed several times, but he's managed to sort of get his case in front of the Supreme Court, including on a very important case about the use of certain drugs, midazolam, for executions. And so his name is sort of known in the Supreme Court. They've dealt with his case before, but he's always had his convictions affirmed and really has never had any success in the courts other than having that first conviction overturned. And that wasn't because of actual innocence or anything. It was just because his attorney was ineffective. But now he's back.
He's back, and he's been before the Supreme Court many times, like Brett said. But what was it about today in today's oral argument? For those of you who are new to the Supreme Court, oral argument happens. A decision is usually not issued right away. So we will not know the court's decision until sometime later this term. Probably not anytime soon, to be honest, especially because this is really only the third day of the term. But what we do have is what happened at oral argument today, which went on for about an hour and a half. And you can hear the justices' questions. And oftentimes those questions are really just declaratory statements. So you kind of see where justices are thinking they'll take the case. So this entire case here today turns on a brief exchange during the trial in which the district attorney asked about Snead's medical history. So as you can imagine, Snead was one of the main witnesses for the prosecution because he admits to being the one who beats Van Treese to death and also gives the prosecution the full story of why he was part of the murder. It wasn't his idea. It was Glossip's. So Snead's on the stand. He's testifying about a lot of things. But at some point, he says that he had a cold and he'd asked for Sudafed. Then Snead kind of has this like small comment where he says he'd also been given lithium, but that he'd never, quote, seen a psychiatrist or anything. So the entire case comes down to that testimony by Snead and a single note from one of the prosecutors written down during this time that said, Dr. Trumpet, ? That's it. Those 2 words. Abbreviation Dr. Trumpet ? No other explanation. It's assumed that Trumpet actually refers to Dr. Tromka, a psychiatrist for the Oklahoma jail where Snead was held. So let that sink in for just a moment. You guys have heard us talk a lot about what allows a conviction to be overturned, what requires a new trial. This all comes down to a note, 30 years ago, saying Dr. Trumpet ? So the first theory, you're saying, what does this mean? What does this mean? What does Dr. Trumpet mean? The first theory is under Brady. Remember, Brady is that you have to turn over all exculpatory evidence to the defense because it may aid them in their defense. So the theory for Glossip is that although the jury knew that Snead had been prescribed lithium, because you can't just buy lithium off the streets, it's something you do have to be prescribed, they did not know why or that he was under the care of a psychiatrist. And the theory is that if the jury had known about his psychiatry needs, this would have affected the credibility of Snead, the prosecution's main witness. Therefore, the prosecution had a duty to turn over that information to the defense. So that's the Brady theory. Remember, we said there's also an allegation of a NAPU violation. So NAPU was a 1959 Supreme Court case that basically held if a prosecutor knowingly allowed false testimony from a witness to be part of their case, like they didn't correct it, they knew it was false, let it slide, and then there was a conviction. If there was like a reasonable probability that that would have affected the jury, then the conviction had to be set aside. So NAPU has to do with false testimony, getting your conviction. So the prosecutor should have recognized that Snead was lying when he said he'd never seen a psychiatrist and corrected this testimony. And because the prosecutor didn't, not only did he know that Snead was lying, he should have corrected it and that it affected the jury's decision when they voted to convict. Then there was a NAPU violation. So those are the Glossip's theories.
And I don't know if you're watching, just put the note on the screen that's in the brief. Can't really see it that well, but basically this is what we're talking about. You've got basically a piece of paper the prosecutor is clearly sort of dashing notes on this piece of paper while they're probably listening to what he's testifying, or who knows exactly when these notes were jotted down. But you do have this Dr. Trumpet ? And yeah.
Real quick question, Brett. We've been to trial together a few times. What does your notebook look like during trial?
Well, you can't read it, number one. Only I can read my notes. And I learned a long time ago, and I'm not saying you should do this, but
I'm saying you should do
when
this.
I take notes, look, I've been in a lot of jobs where your notes become part of some sort of public record, and you really just don't want somebody reading those notes one day on the floor of the Senate. And I write basically in shorthand. I can read what I've written, but nobody else can read what I've written. So you can take those and take them to the National Archives all you want, but you're never going to be able to read them.
So what I was trying to get at, yes, here's Brett giving you FOIA advice, anti-FOIA advice. But trial is so fast moving that, yes, I write in shorthand, but also like they are the farthest from complete notes you could ever have. The fact that you could even write out a whole like Dr. Trumpet ? That actually is pretty accurate. Like Brett and I would pass back and forth Post-it notes. We would go through like 10 pads of Post-it notes during a trial, literally with like a question mark on it with like no words, because we're just trying to convey something to each other because you can't talk audibly in the courtroom. And you certainly wouldn't say things like, this note was written during Sneed's testimony during a crucial moment in which he said, never seen a psychiatrist. Dr. Trumpet ? No, like that's just, you don't have enough time to write those notes. You literally are like underlining things, circling things. And this is important to note here because there's no other context with this note. But this entire case is around this one note.
And the other thing, and what's fascinating about this, and one thing that's a little troubling about the Supreme Court argument, and we're going to get into that, but as Alice said, when this stuff's going on, you're in the heat of the moment, you're dashing stuff down. A lot of times, I don't ever follow up on that. Like I had a thought, I wrote it down. I may look at it later and have no idea what I'm even talking about. Like, why'd I write that down? I mean, the number of times that happens where I'm like, I don't know what that means. And I just move on, right? And I think this is important to remember when you hear these cases, because there's this notion, and a lot of people in true crime like to put it out there, that prosecutors are all these like evil, conniving people, and they know all this information, and they're just trying to convict innocent people all the time and violate their rights. And in reality, with stuff like this is sort of your typical Brady whatever attack. You have some random thing that was written down somewhere, and the defense is going to say, look, clearly, when she wrote Dr. Trumpet down, she meant Dr. Trumka, and what she was saying was, but didn't he see Dr. Trumka, and shouldn't we tell the defense that so they're aware of it and possibly correct the obvious perjury he just gave? No, she may be like, I just want to check on this later, so I'm going to write this down, so if it was wrong, I'll correct it later, right? And then just never does it because the trial's moving on and there's 1,000 different things happening.
Yeah, especially because you can read the transcript. It's not like 15 or even 10 minutes were spent on this. This was literally like 2 lines in the transcript. They were talking about the murder and him like beating someone to death and Glossip telling him to do so and whatnot. Right. So this is not like the entire case turned on his mental state, because actually his mental state was at issue here. We heard from his own voice that the reason he did this is because Glossip knew that he could control him because he's not very smart. Probably has other mental issues. That is part of the case.
And look, obviously, you're a defense attorney. You're trying to save this guy's life. You're doing the best you can. You've lost everything you've ever done. You find this note and you're like, let's see if we can make something out of this. And so you're going to make that argument. And that makes perfect sense. And I'm not saying this shouldn't be litigated. I'm not saying it shouldn't be addressed. But this is not one, and I hope you see this even from our discussion of it, it's not one that is so clear that you're like compelled as a prosecutor or an attorney general to immediately act to remedy this injustice.
Let me give a counter example. I could see it maybe being a little more compelling if the note read something instead like, that's a lie? ? Right? That goes more to something like, is it a lie? Here, we have no idea. They could literally be like psychiatrists. Like, I do this all the time. The first time someone mentions a doctor, I'm like, is that this doctor? Do we have notes on this? Is he a witness? Did they call him? Are they going to subpoena him? Like, there's so many things that could be going through your mind in terms of, oh, is that going to be a rebuttal witness then that they're going to talk about? Because maybe they're going to show he's actually mentally strong enough to make his own decisions and Glossip is framing him. You see how many ways this note could be read, and we're explaining this because there's no other context here.
Or a situation like in the Alec Baldwin case. We talked about this earlier, where in the middle of trial, you have this evidence that just appears, and you're like, oh my goodness, that's the same. Those are the same types of rounds we're talking about. How did we not turn this over to the defense? This could have changed their entire approach. I mean, everything about this case now changes because of this, right? And it's happening in the middle of trial, and you're a prosecutor, and you're confronted with that. And we talked about how difficult a decision it was in that case for Erlinda Ocampo Johnson to make that decision and how difficult that was. Then you have the situation you're in. If you're at this point in the case 20 years later, where you are the state and you're sort of representing the prosecution, and you know there are going to be attacks on the case, and it's your duty to defend the prosecution unless it is so clear that an injustice occurred that you have to confess error. That is supposed to be the standard. Your job as the attorney general of a state is to defend convictions if they can be defended. That is your job. In this case, though, astonishingly, in the lower court, so Glossip files his challenge, which is perfectly within his rights, rather than make all of the arguments that were made in the Supreme Court today. For instance, I'm irritated, as you can tell, a little bit by the Oklahoma Attorney General's position on this. But in the lower court, the Oklahoma Attorney General, while maintaining that Glossip is guilty, decided to move to vacate his conviction, to join Glossip's attack on the conviction on the basis of the psychiatrist issue under NAPU.
I listened to the argument today and I giggled every time they said NAPU, so it's like burned into my brain.
Okay, NAPU. So he does this, which is an extraordinary thing to do. And ordinarily, as we've seen before, when the prosecution and the defense join each other, you would expect that of the 5 judges who hear the case, maybe at least one of them would agree with the Oklahoma Attorney General. None of them did. In a unanimous opinion, the Oklahoma Court of Appeals rejected the AG's decision. Now, this is in of itself strange, because now you have the chief law enforcement officer in Oklahoma, the attorney general, saying you should vacate this conviction, and the court essentially saying, no, we're not going to do that. We do not agree with what you're saying. And they said this for a couple reasons. First, the court found that the appeal was procedurally barred. Now, what does that mean? So we talk about the substance of these cases all the time. Is this a Brady violation? Is the person guilty? Are they actually innocent? But they're all finality. Finality in the courts matters a lot. And we have this system that basically says, if you're going to challenge a conviction, you have to follow certain procedures. If you do not follow those procedures, your attack is barred. And under Oklahoma law, Glossip was required to show, among other things, that the issue at hand, the one that he's arguing about, this whole notion of the psychiatrist, and whether or not he'd had a psychiatrist, and whether or not he had lied on the stand, was not ascertainable through the due diligence of his own attorneys. So NAPU and Brady are not licenses for defense attorneys to turn a blind eye. It does not give them permission to ignore their own duty to investigate, their own duty to follow up on issues. We're not trying to let them hide the ball and then be like, aha, now you have to start this whole thing over again. And counsel knew, both his trial counsel and his subsequent appellate counsel for the last 20 years, knew that this individual, Sneed, was on lithium. They knew that because it was testified to in front of the jury. And if you're on lithium, guess what? It shouldn't be that hard for you to figure out that a psychiatrist probably prescribed it. That is something that if you're the attorney, you should follow up on. And when you don't follow up on it, to a certain extent, that's on you, not on the prosecution. As we said before, we recognize prosecutors, police are not perfect. Trials are not perfect. Mistakes are going to happen. And we're really only going to do something about this when those mistakes are egregious or they're intentional or there's no way that the defense could have, doing their job, seen this problem arise. And in fact, this is not a mystery. It's not a mystery to anyone why they didn't dig into this, because the fact that Sneed had mental issues that made him more susceptible to being taken advantage of was part of the prosecution's case. And the defense didn't want to dig into the fact that he had seen a psychiatrist. They did not want to dig into his many mental illnesses, which led to him being prescribed lithium, because they knew if they did that, it would be bad for their case. So they made a decision just to let that lie.
And you can see how it's not a situation where they completely failed to follow up on something, because it was known that Snead was, quote, mentally vulnerable, right? That goes to the prosecution's case. And if they harp on it, you can see how that's a real strategic decision not to press more upon it. The more you show that he's like mentally vulnerable, the better the case the prosecution has, right? That he can be manipulated. Because most of us, if someone knocked on our door and said, hey, go beat this person to death, most of us would be like, no thanks, not going to do that. So why does this guy do it? Because he's mentally vulnerable, right? And so the more time you spend on the fact that he's getting prescribed lots of stuff, that he's seeing a psychiatrist, I don't know that's why the strategy goes into it, but you can certainly see how that has a strategic component to it. And it's not a situation where the jury had no idea this was a mentally vulnerable person. The whole basis of who he is and why he agreed to do this is because he was self-described as needing direction.
So what's interesting about this is because you have these two arguments by the court, the other thing they did is they actually went to the substance. They looked at the substance. They said the evidence wasn't material under Brady or Napoo, that it wouldn't have changed anything, that this was a very minor thing in the grand scheme of the case, that given all the other evidence and given all the other testimony, this wouldn't have mattered anyway. That's the substance. So they've made a decision on two bases. Number one, procedurally, and number two, substantively. The procedural basis is important because that is what we call an independent state ground. So if there is a state ground on which a case is decided, the fact that we call it the Supreme Court doesn't actually matter. If the case is being decided on a state law question, the Supreme Court does not get to review that. They lack the jurisdiction to review it. They can only review questions that arise under the federal Constitution. So the substantive question, Brady and Napoo, those are both things that arise from due process and from the various rights you have under the United States Constitution. If the Oklahoma court decided this solely on that, that would be something the Supreme Court can definitely review. But if there's an adequate and independent state law reason that this can't be heard, the Supreme Court can't review that. So the fact that the Oklahoma Court of Appeals does this sort of first, procedurally barred under state law, second, even if we got to it, you lose, means that the person arguing for the conviction can say to the Supreme Court, you don't even have jurisdiction to consider this. And what you should actually say is, we don't have jurisdiction. Oklahoma said what they've said. Sorry, we can't even get into the substance. But if you do get into the substance, decide in our favor. It's essentially the argument that was made.
And remember, this is because of the two sovereigns idea, right? Why America exists. We were a bunch of states and they were all wary of the king from England that they fought a revolution against. And so there were like the state sovereigns and then the federal sovereigns. And there's two separate sovereigns. And so you can't get over a procedural bar like this. Like, it's just, you don't get to weigh into the merits at all. So when you go to the Supreme Court, there are things called questions presented. It's not just like here's my case. You have to specifically ask the court about questions so that you can dig into it, everyone can brief it properly. So the questions before the court were, do they lack jurisdiction because an adequate and independent state ground exists, like we just talked about? And if not, does the available evidence suggest that a Brady or Napoo violation occurred? And third, should there be an evidentiary hearing to dig into this more because of what we told you about the facts, where this is all turning on the Dr. Trumpet ? Note from the prosecutor, which, by the way, this comes up in oral argument, but you may think, oh, well, the prosecutor who wrote the note, surely they spoke up, or like, this is what I meant by it. This is why Glossip has this position, or the alternative. And so the third question is whether there should be an evidentiary hearing. So let's talk about the first one, because this really took up most of the argument, as it should, because if there's a procedural bar, if there's a jurisdictional bar, then the Supreme Court cannot weigh in at all. And here we know that the Oklahoma Court of Criminal Appeals held that Glossip's claims were barred by a state law that prohibits courts in capital cases from reviewing issues that a prisoner could have raised earlier in the case. You knew about the lithium. You know that lithium has to be prescription only. Not that hard to figure out what kind of doctor ultimately prescribed it. Independent state law, sorry, jurisdictional bar, you don't get to go to the Supreme Court. Now, the justices asked a lot of questions on this point because this is a gateway question. You can't go to the merits of Napoo or Brady if you can't cross this jurisdictional bar. Now, Justice Sotomayor, she comes in hot and she takes the position, which Glossip obviously agrees with, that this is not important. This is not important of a question. It's not a non-issue because this law could not serve as an adequate and independent state ground that would preclude the Grand Supreme Court from weighing in not because it's not independent state grounds, but because the Attorney General of Oklahoma has waived that argument and its right to rely on the law. And she claims this, that state law, the Attorney General can give up their right to argue a law about the state that the state court relied upon to ensure that justice is done. So that any Attorney General can be like, nope, I am myself removing this jurisdictional bar by waiving my right to rely on this law. Of course, Attorney General Drummond takes this position as well, because that's the whole point of joining Glossip in the vacation of the conviction. Brett, what do you think about that?
Yeah, I don't agree with this because
it can't be jurisdictional. You can't waive jurisdictional questions.
So it's a complicated issue because it's a jurisdictional question if it's an adequate and independent state ground. But it's only an adequate and independent state ground if they didn't waive the procedural bar. If they waive the procedural bar, then they have jurisdiction because they're actually deciding the substance. So the question is, can he waive a procedural bar that would, in effect, waive a jurisdictional bar? Which is very strange to even think about it that way. But the second thing, I have written a lot of briefs where I have at various times said things like, the government does not contest this. The government waives this issue. And a lot of times the courts will say things like, although the government waives the issue, we are not bound to accept that waiver. But we do anyway, and they move on, right? Sometimes they just want to make it clear, just because you waived it doesn't mean we couldn't address it. But we're going to let it go. Right. And you see this a lot in timing stuff. So, for instance, in the federal system, you have 14 days after your sentence is issued, judgment is issued, to appeal. That 14 days is not considered a jurisdictional bar, but it is considered what they call a mandatory claims processing rule, which means if the government raises it, then the courts are bound to dismiss based on it. So it's not a jurisdictional issue, but they have to do it. Right. Now, the question is the converse. What if the government says, it's been 14 days, but we're not going to press it, right? Say it's been 14 years. Say it's something been ridiculous. But the government's like, we're not going to hold them to their 14 days in the rules. Could the court say, look, we have the rules for a reason. And one of those reasons is to ensure that we don't have these really old stale appeals coming up. So it's great, government, that you want to let them do this 13 years and 341 days late, but we're not going to accept that. And essentially what the Oklahoma court said was, that's great that you want to waive this procedural bar. We're rejecting you being able to do that. We reject your waiver. We say you can't waive it in this instance. And the Supreme Court is having to answer this question. Can the Oklahoma Supreme Court do that? I'm going to keep calling the Oklahoma Supreme Court because it's easier than the Oklahoma Court of Appeals, which is what it was. And I just got to tell you, I think it is really not the Supreme Court's place to tell the Oklahoma Court of Appeals whether or not they have to waive a procedural bar. I didn't like that. I felt like that whole discussion to me was why are you getting all up in Oklahoma's business about when they, the state, can decide whether or not to waive this or not? The court made it very clear they're not waiving it. They made it very clear that their opinion of Oklahoma law is they can decide not to waive it, which to me is a purely state law question. Yeah. So why are you talking about that? But they talked about it the whole time.
There's a lot of talk about it. And not every justice obviously kind of took that position. And again, I would say, I don't know, 3/4, felt like 3/4 of the argument focused on this question. And I mean, a lot of you are asking, so Attorney General Drummond's counsel, Paul Clement, and Glossip both agreed with that position because they don't want to be barred. They want to go to the NAPU and the Brady issue because that's when, the action happens. Because if they're barred, then they have no claim, right? And so it's not surprising here that two of the parties, I guess, they're really one party at this point, argued together. Now, we're already going 42 minutes. Look at that. Okay, so if you get over this procedural bar, let's say that they don't agree with the state court. I think they should, but let's say they move on. Then We have all the evidence before us. Remember, this is a case that's been tried twice. It's been affirmed on appeal 6 or 7 times. We have really all the evidence. And I don't think any new evidence is coming out here. With the available evidence, does it suggest that there's a Brady or NAPU violation? Of course, Glossip claims there's a Brady violation and a NAPU violation. So would the question of lithium or seeing a psychiatrist have affected the jury? And it's really not about the lithium. It's really about the bipolar diagnosis. And one of the justices kind of brings this up, isn't it, about whether he had bipolar disorder or not. This, again, goes to the strategy that we were talking about. I think everyone knew that he had things he was dealing with mentally. Whether there was a name to it or not is questionable. But the question is, if they had known that, would that have changed what they said? And kind of like you may be hearing some of our skepticism just because we practice this all the time and I know what my notes look like in trials. A couple of the justices kind of question Glossip whether he's reading too much into the prosecutor's notes. I don't think it's notes with an S. I think
Two
it's
words
nota.
and a question mark.
See, singular. It's Dr. Trumpet question mark.
Which isn't even the doctor's name that we're talking about. We're assuming she's talking about
it's not
that
the doctor's name, right? A typoed doctor name. Whether that really one line, if Glossip is reading too much into it, to even say that the prosecution knew this was false testimony and that this is what affected the jury's decision. It's a valid question. I mean, whether you agree with that or not, I think it's a valid question to ask, because if you reach the merits, which I think the Oklahoma Supreme Court said, even if you get there, it doesn't matter. There's no Brady or NAPU violation here. And you can see that the record is relatively thin. We are not, again, talking about a situation where we have this like extensive record where it's like, well, this is very concerning. Because trust me, when it's super concerning, the courts somehow always find a way to jump over that jurisdictional bar to get to it.
Yeah, which is, well, I mean, look, Justice Kagan talked about the jurisdictional bar and basically was like, well, isn't it just the lower court's they really don't want this to succeed. So they're just saying that they're doing that, and that's their way to prevent us from reviewing it. I don't know, Justice Kagan, maybe they are, but guess what? They can do that. I mean, like the notion that like, well, they're lying to us about what their decision is. No, they offered 2 reasons, which the Supreme Court has been very clear. You can offer an in the alternative reason as a court. You can say, this is our reason for rejecting this. But in the alternative, should some reviewing court one day say we got that wrong, by the way, we also believe that this is the correct decision based on this other argument. The fact that they mention the other argument, that they're frankly saving time, because you can imagine if they had just decided it on the procedural grounds, what's going to happen? Then it goes up to Supreme Court. Supreme Court says, you know what, we think you got it wrong on the procedure, but we can't even decide on the substance because the court didn't address it. So now we got to send it back down to the appeals court so they can consider the substance. They just considered both. And this notion that somehow that undermines them, as I mean, if you don't think it's an adequate and independent state grounds, fine. But don't act like the court didn't believe that. They clearly did. That's what they said in their opinion. They made it very clear that was their primary reason for doing this. And what's interesting about this case, there's basically no law on this. There was like one case that kept coming up that they sort of talked about a little bit, but nobody could ever really point to anything beyond that. And even that case wasn't really on point. So the Supreme Court's going to be making some new law, which may be concerning law.
Which is why it's before the Supreme Court, right?
Right. And could really limit state courts and the really independence of the state judiciary, which I think is a problem. But the other issue, the one that no one brought up, that bothered me the whole time. So we're just assuming he lied. He lied on the stand. How do we know that?
We know he's mentally fragile.
Exactly. How do we know he knows
he may not
whether
know
the
who
doctor
Dr.
was a
Trumka
psychiatrist
is.
or not? Yeah. There's no reason. The doctor, it's like, why would he assume the county jail had a psychiatrist and not just some doctor who gave him lithium? Thank you for bringing this up,
because this was in the back of my mind the entire oral argument. I was like, what are we pointing to that Snead even knew he was lying? There's one question of whether the prosecutor knew he was quote unquote lying. You have to have like intent to lie, right? But like you see a lot of people, especially if you may just go in the clinic, right? You may not know who you're seeing in general. And I mean, he asked for Sudafed. He thought he had a cold. I mean, if someone gave me lithium instead of Sudafed, I'd be like, whoa, why? He didn't even question that. He was just like, I don't know, I got me some lithium for my cold. Like,
I'm sure he was happy to get. I mean,
he was happy to get whatever to get, right? Sorry to cut you off there, but like, thank you for bringing that up, because the whole time during the argument, I was like, did he lie? Because you have to have intent to lie. I don't know that Snead lied. I don't know that anything in the record indicates that Snead thinks he lied. I know we've talked about the Supreme Court having 9 justices. So remember how we told you this Glossip case has been up and down all over the courts for like decades? Well, Justice Gorsuch is recused from this case. So 8 justices heard this case. And I assume, I didn't look into this, but I assume he's recused because he was on the 10th Circuit Court of Appeals as a judge before going on the Supreme Court. And he sat on the 10th Circuit. Oklahoma is part of the 10th Circuit. So he would have heard Glossip's case probably all the previous times before joining the Supreme Court. And when there's a case before you that you previously worked on, you recuse yourself. And so this is an 8-justice case, meaning if it splits 4-4, when you have a deadlock, do you know what that means? It doesn't mean nothing happens. It means that the court below's decision stands. So if they gridlock, then Glossip loses. But because that is the outcome if they gridlock, which based on the questioning today, probably could be a 4-4 split. I agree with you, Brett. We talked about this before, but what do you think will happen in this case?
Well, I think there's a real chance of a 4-4 split on the substance, I think there was some pretty strong telegraphing that maybe an evidentiary hearing would be necessary, which is what should have happened before if the AG of Oklahoma had done what he was supposed to do. Maybe we could have had that evidentiary hearing and really hashed this out about exactly what happened and exactly what the notes meant and exactly what Snead thought. Maybe we could have gotten to the bottom of that instead of, I don't know, just detonating a bomb in the middle of the case, which means we have to go in front of the Supreme Court and they're asking a bunch of questions that nobody knows the answers to. And it was pretty clear that Alito and Thomas are totally against Glossip. They're against Glossip. And Kagan and Sotomayor are with him, which leaves Justice Jackson, Justice Barrett, Chief Justice, and Justice Kavanaugh. Those are the ones we've got. Justice Jackson asked a bunch of questions about an evidentiary hearing. Like, why don't we just have an evidentiary hearing? None of the lawyers wanted an evidentiary hearing.
Valid question, Justice Jackson.
Yeah.
That's what should have happened.
I mean, when she asked the question, I was like, exactly.
Yes,
that's exactly what should have happened.
Justice
I don't know
Jackson.
why that didn't happen.
And that I think that was the most telling, that all 3 lawyers were like, I mean, Justice, if that's what you want, we're not going to fight it. But no one was like, yeah, I agree. Let's have an evidentiary hearing. And that is also telling in and of itself.
I mean, Paul Clement, once again, the greatest oralist of his generation, was just basically like, I mean, that's a great question. Why do we have that? I mean, we didn't fight having it, but I guess, we didn't ask for it. But if that's what you want to do, that was pretty much his position. And then Glossip,
which is about as non-position as a position as you can get.
Yeah, Glossip definitely doesn't want to have one, because I'm just going to go out on a limb. If there's an evidentiary hearing and someone decent, i.e. not the AG, is able to represent the conviction, the evidentiary hearing will not be good for Glossip. So he definitely didn't want to have it. And I mean, we'll see what happens, but Kavanaugh, the Chief Justice, and Barrett, I think the Supreme Court, on these death penalty cases in particular, I mean, they let a lot of them go through, but they recognize they're the last voice on this, and they really don't like pulling the trigger on it. I mean, they just don't, right? I mean, they send these cases back all the time.
I mean, there's a reason why this is before the court yet again, right? They granted a stay in order to hear these appeals.
Right. And I think what's going to end up happening is Jackson, Barrett, the Chief, and Kavanaugh will want to have an evidentiary hearing. The Kagan, Sotomayor will want to just grant, but they won't have enough votes for that. So they'll end up joining the other 4, and you'll have a 6-2 opinion sending it back for an evidentiary hearing. That's what I think will happen, and this will just continue to drag out. And that's unfortunate because, I mean,
they're going to appeal that evidentiary hearing. I think that evidentiary hearing will yield nothing, but it's going to delay this. There's not going to be justice.
And then it'll go back up to the Supreme Court again.
Again, one thing to note, the Attorney General of Oklahoma stands by the fact that he thinks he's guilty, right? I don't really think anyone, maybe some of the I don't know. I think the justices think he's guilty. This is not about his guilt or innocence. It is about due process, which is very important. But we've already spoken for 50 minutes about what we think about the record in this case. And I do think you're right. I don't think they want to be gridlocked because, you take all this effort, tens of thousands of cases like are petitioned to the court each year, and they only take like 70 to 80 to oral argument. It's the least satisfying decision to just gridlock and say, no, because we're 4-4. So I think they're going to do something, which is the evidentiary hearing, which will be another year. And then we'll see maybe Glossip back at the Supreme Court in another year or two for another season.
I don't want to, wish any ill will on the people of Oklahoma, but I'm hoping that Drummond will go ahead and buy the governorship next so he can move up into that. And then a new AG can come in, maybe one who's a little bit better at his job. And that person can decide to handle this the way we handle cases, which is they're going to defend the conviction and make the best argument they can. Glossip will make the best argument he can, and the courts will decide who has the better answer. That's what I'm hoping will happen, because I'm not very confident that under the current regime, things are going to get much cleaner or much better in the courts in Oklahoma when it comes to this case, but not just this case, several other cases in Oklahoma, which are pretty high profile, that the AG has taken unusual positions in. And we'll just have to see what happens. But if I had to bet, I'm going with evidentiary hearing is the way it's going.
Indeed. Well, this has been fun, guys. Thanks for joining us for this new season of the Supreme Court. This was very requested, by the way. So if there are other cases as they're being argued, obviously we won't know what the Supreme Court says until later this term, and we'll cover it whenever it comes out as an update. Let us know, because there's a lot of cases that maybe are less interesting to you and we don't want to bore you with it. So let us know. You can write to us at prosecutorspod@gmail.com, and you can find us on social media, Instagram, Facebook. You can join our fan-based Facebook group, The Gallery, which has amazing discussion all the time about things that we discuss on this podcast and the other podcast, Prosecutors Pod, and otherwise very smart people. With that, Brett, do you have anything else you'd like to add?
No, but just it is a new season of Supreme Court. We'll try and cover the cases that you're most interested in. Let us know what you want to hear about, and we'll talk about them.
Indeed. Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
It's already getting fired up. It just irritates me.
Well, I mean, we were fired up before we even went live.
You have a job.
Because I was like, what is happening?
To do. Do your job. Do your job.
That's
all
the thing.
ask.
It's just to do your job. It costs people time and money. I don't like. I'm an immigrant. I like being efficient. And I don't like waste. And I
don't like politicians who make decisions based on getting a sound good in the press release.
We even talk about how he made this decision because he hired a law firm who he spent 600 hours on the case to basically
seriously?
Yeah.
600
he billed
hours?
600 at Oklahoma.